5 seconds to go. Start. This reference to the larger bench of 5 judges arises out of the writ petitions filed challenging the notification number 3407E dated 8 November 2016, hereinafter referred to as the impugned notification issued by the central government in exercise of the powers conferred by subsection 2 of section 26 of the Reserve Bank of India Act 1934, hereinafter referred to as the RBI Act, by which the central government declared that the bank notes of denominations of the existing series of the value of 500 rupees and 1000 rupees shall cease to be legal tender with effect from 9th November 2016 to the extent specified in the impugned notification. This is popularly known as an act policy of demonetization. Immediately after the impugned notification was issued, several writ petitions challenging the policy of demonetization came to be filed before this court as also before various high courts. Transfer petitions were filed by the union seeking transfer of all such matters pending before the high courts to this court. A bench of learned 3 judges of this court passed an order dated 16 December 2016 in writ petition civil number 906 of 2016 and other connected petitions, observing therein that, in their opinion, following important questions fall for consideration: whether the notification dated 8th November 2016 is ultra vires, section 26(2) and sections 7, 17, 23, 24, 29 and 42 of the Reserve Bank of India Act 1934. Does the notification contravene the provisions of Article 300A of the Constitution? Assuming that the notification has been validly issued under the Reserve Bank of India Act 1934, whether it is ultra vires, Articles 14 and 19 of the Constitution, whether the limit on withdrawal of cash from the funds deposited in bank accounts has no basis in law and violates Articles 14, 19 and 21, whether the implementation of the impugned notification suffers from procedural and or substantive unreasonableness and thereby violates Articles 14 and 19, and if so, to what effect? In the event that Section 26(2) is held to permit demonetization, does it suffer from excessive delegation of legislative power, thereby rendering it ultra vires the Constitution? What is the scope of judicial review in matters relating to fiscal and economic policy of the government? Whether a petition by a political party on the issues raised is maintainable under Article 32, and whether district cooperative banks have been discriminated against by excluding them from accepting deposits and exchanging demonetized notes. Via the said order dated 16 December 2016, this court also directed that if any other writ petitions proceedings were pending in any high court, further hearing of those matters should also remain stayed. This court further directed that no other court should entertain, hear or decide any writ petition proceeding on the issue of or in relation to or arising from the decision of the Government of India to demonetize the notes of rupees 500 and rupees 1000, since the entire issue in relation thereto was pending consideration before this court. Before we consider the matter, it will be necessary to refer to certain facts. On 8th November 2016, via the impugned notification, the central government, in exercise of the powers conferred by subsection 2 of section 26 of the RBI Act, notified that the specified bank notes hereinafter referred to as SBNs shall cease to be legal tender with effect from 9th November 2016. The SBNs were bank notes of denominations of the existing series of the value of rupees 500 and rupees 1000. Under clause 1 of the said notification, every banking company and every government treasury was required to complete and forward a return along with the details of SBNs held by it at the close of business as on the 8th November 2016, not later than 1300 hours on the 10th November 2016 to the designated regional office of the Reserve Bank of India, hereinafter referred to as RBI. Insofar as the individual persons were concerned, under clause 2 of the impugned notification, they were entitled to exchange SBNs in various banks specified therein up to 30th December 2016, subject to certain conditions. Initially, it provided a limit of rupees 4,000 for such exchange. It also provided that the limit of rupees 4,000 for exchanging SBNs shall be reviewed after 15 days from the date of commencement of the impugned notification. It further provided that insofar as Know Your Customer KYC compliant bank account maintained by a person with a bank was concerned, there was no limit on the quantity or value of the SBNs that could be credited to such an account. However, insofar as non-KYC compliant bank accounts were concerned, an outer limit was fixed at rupees 50,000. There were certain other provisions made under the impugned notification. Stop.